Okay, good morning, everybody. I'm Carlotta Minella from the Migration Policy Center. Welcome to today's research seminar. Our speaker today is Dr. Maciej Grześkowiak, who holds a PhD in law from the University of Warsaw, where he also lectured in human rights law. He also is a research affiliate at the Refugee Law Initiative at the University of London. And his research focusing on international EU migration and asylum law. He is here at the EUI as a Max Weber Fellow at the Department of Law. He will be speaking to us today about the gap between temporary refugee and asylum, how international refugee law entrenches crisis. So just a couple of housekeeping rules. You will have 25 minutes to speak, and then this will be followed by Q&A. For those of you who are online, you can either raise your hand or preferably just write your questions in the chat, and I will get back to you after a first round of questions from this room. Okay, I'll just mute the floor.
Thank you, Carlotta. I'm very happy to be here today and to present to you the core sort of premises and arguments that I'm trying to make in my forthcoming book. This book used to be my PhD thesis. Now it's forthcoming with Brill, hopefully in a couple of months. So the title of the book is The Gap Between Temporary Refuge and Asylum, How International Refugee Law Entrenches Crisis. And let's get right into it. So the problem that this book tackles is this global shift towards temporary, emergency-driven forms of protection of displaced persons at the expense of asylum. What I mean by that is that in situations of large-scale emergency refugee influxes, states increasingly resort to temporary refuge or temporary protection. I will explain what I mean by those in a second, at the expense of forms of durable asylum, that is chiefly refugee status or complementary protection. Now, these statuses, that is temporary refuge or temporary protection, they are explicitly cast as temporary measures, as emergency measures, yet they tend to stick beyond the emergencies that justify triggering them. When you think about this phenomenon of entrenchment of emergency-driven forms of protection, think about what happened to Ukraine refugees in the EU, Venezuelan refugees in Colombia, or Syrian refugees in the Middle East over time. Now, the main argument that the book is trying to make is that international law enables and at times also encourages such outcomes, that is, this entrenchment of those emergency-driven forms of protection. To conceptualize this phenomenon of entrenchment of temporary refuge, the book introduces the concept of the gap between temporary refuge and asylum. On the slide, you see the definition. It might sound a bit convoluted at this stage, but I will spend the rest of the talk shedding more light on it. So it is an inadequacy inherent in the international refugee law, which permits a situation whereby persons protected on the basis of the principle of temporary refuge are denied a stable status over extended periods of time, despite the declaratory temporariness embedded in the principle and its promise, to facilitate the obtaining of durable solutions. Now, in order for you to grasp what I'm getting at with this concept of the gap between temporary refuge and asylum, I first have to spend a few minutes describing what I mean by its two quote-unquote poles. So asylum on the one hand and temporary refuge on the other. So starting with asylum. To conceptualize it, I borrow from Guy Goodwin Gill, Jane McAdam, and Emma Dunlop, who in their book, The Refugee in International Law, understand asylum as a durable or permanent solution involving residence and lasting protection against the exercise of jurisdiction by the state of origin. So understood as such, asylum is this umbrella term. It can encompass different forms of protection of forcibly displaced people, but at the minimum, as per this definition, it requires this sense of durability resulting in the sense of legal stability in the state of refuge, and it must go beyond this sort of mere tolerance of presence of displaced persons. So it must confer some substantial rights on protected populations that could allow meaningful inclusion in the host community and, with time, possibly local integration. So if you look at international law and statuses that it provides for, what comes to mind that meets this definition of asylum is first and foremost refugee status, that is granted on the basis of the 1951 Refugee Convention, and under some circumstances, but under some circumstances only, complementary protection. Complementary protection is the status granted to people who are displaced, who cannot be returned to their countries of origin by virtue of the principle of non-refoulement, yet cannot obtain the refugee status. I will explain this distinction between refugee status and complementary protection and how it relates to the argument advanced in the book now. So refugee status, the book understands as this sort of model full asylum under international law. That's because if you look into the Refugee Convention, it provides for this list of rights that refugees are entitled to. And those rights are, by all standards, substantial. They guarantee social rights, economic rights. They allow for self-sufficiency and possibly, with time, integration. There is a caveat in the Refugee Convention, and you're probably aware of it, and that's a very narrow definition of refugee. And hence, the threshold for obtaining refugee status is difficult to meet. Refugee status benefits only a small part of the worldwide population of displaced persons. And this is because the Convention's definition of refugee requires for the status to be granted this individualized threat of persecution in the country of origin. And this leaves outside of the scope of this definition people who flee indiscriminate events, so not underpinned by this persecutory situation. Think about, for example, persons who fled because of indiscriminate bombings of civilian neighborhoods in the armed conflicts. If such bombardment is not underpinned by persecution of certain populations inhabiting those neighborhoods, it cannot be construed as being persecution under the refugee definition. Such people, however, are covered by what we call complementary protection. So this is the status that is assigned precisely to people who cannot be returned because of certain fears that they have about returning to their countries of origin, yet they cannot meet this definition of refugee provided for in the Refugee Convention, either because they do not meet this persecution requirement, or they find themselves in states that are not parties to the convention and thus do not recognize refugees as such at all. Now, contrary to refugee status, there is no uniform, readily available status of complementary protection under international law. There is no treaty like the 1951 Refugee Convention that would provide for this list of rights. Instead, the status of complementary protection must be ascertained on a case-by-case basis, looking at international obligations of a state in question. And only under some circumstances, this status will meet this definition of asylum that I put on the slide before. So in particular, because of the International Covenant on Economic, Social, and Cultural Rights, namely Article 2, Section 3, so-called developing countries under this covenant are not obliged to grant economic rights to foreigners at all. And so in such circumstances, when no economic rights are granted, such a status cannot be understood as asylum, because then there are no positive rights that would allow for any sense of self-sufficiency and with time integration. So to sum up this part, refugee status can be understood as asylum under all circumstances, complementary protection only under some circumstances. Now, the principle of temporary refuge, so the second, so to say, pole of the gap that the book examines. This is the concept that emerged in late 1970s as a response to mass flight from the Indo-Chinese Peninsula. And what it is, it's basically a mechanism of a de facto suspension of regular asylum systems that are usually premised on this very individualized assessment of each case in favor of immediate and group-based, and this is crucial, temporarily and qualitatively limited protection in situation of mass influx. What it means is that when temporary protection is, or temporary refuge is triggered, there is usually this quantity versus quality trade-off. That is, quantity of admitted people versus quality of their protection. So the assumption is that because we have to admit and accommodate so many people crossing over this very short period of time, the quality of the rights that we confer upon them must be narrower than full asylum. Quantity versus quality trade-off. Quantity of admitted people versus quality of their status. Because there is this trade-off, there is also an assumption that protection on the basis of temporary refuge must only be temporary. And with time, it should come to an end. And either, if safe repatriation is possible, people should come back home. If it's not possible, temporary refuge should transition to something more durable, more lasting, guaranteeing legal stability, broader rights. Now, in some contexts, temporary refuge evolved into what is known as temporary protection regimes. We know it from the EU, but also from Turkey or from Colombia. Now, having said a few words about the two poles of the gap between temporary refuge and asylum, I can say a bit more about the gap itself. The book argues that it emerges essentially in those two scenarios that you see on the slide. First, when there is no status bearing the features of asylum that temporary refuge could transition to. And this is what happened, for example, in Lebanon to Syrian refugees. Or secondly, when persons protected under temporary refuge are formally entitled to asylum, yet a state in question, a state where they are, disincentivizes them from applying for asylum. And this is the case, for example, of Ukraine refugees in Poland. And I will spend the next few minutes talking about these two examples. And starting with Lebanon. So Syrians, as probably all of you know, were admitted there in huge numbers post-2011, post-Syrian uprising that, as we all know, evolved in a very long and bloody civil war. Lebanon was very, very careful from the outset not to suggest that it was willing to provide these people with asylum or to provide any integration opportunities. They were branded not refugees, but rather temporary guests. However, it must be noted that Lebanon was actually never required to provide Syrians with asylum. Why? Well, foremost, it is not party to the 1951 Refugee Convention, and so it is not obliged to recognize refugees as such at all. And it doesn't do it. It doesn't confer refugee status at all on anyone. Secondly, it could easily be classified as a developing country under the International Covenant on economic, social, and cultural rights, and thus complementary protection that it is obliged to grant does not meet the threshold of asylum. And so the result is that there is simply no asylum, as per the definition that I put on a few slides before, that temporary refuge could transition to. And this caused the entrenchment of Syrian status at a deeply precarious level, which in turn pushed them to social exclusion. Now, the case of Poland, exemplifying the second scenario where the gap between temporary refuge and asylum can emerge. So Ukraine refugees, as you all know, I'm sure, are protected in the EU under the EU-wide temporary protection scheme. It must be noted, maybe only as a footnote here, that this status was extended very, very controversially by the Council beyond what was previously understood as a 3-year limit. So as per the dominant interpretation of the directive, temporary protection in the EU should last for 3 years maximum. And then it should come to an end. It should transition to another status, or alternatively, repatriation could begin if it was safe. However, a very controversial decision was made to extend it to 2027. However, Ukrainians in Poland and across the EU, for that matter, can always apply for regular international protection, that is, for either refugee status or subsidiary protection. But in Poland, they're strongly disincentivized from doing so. How? Well, there exists this mechanism in Poland as per which submitting an application for international protection equals immediately forfeiting temporary protection status and instead acquiring the status of an applicant in international protection proceedings. So, for example, the moment when a Ukrainian refugee submits their asylum application, they lose the right to work, for example, which the applicants in asylum proceedings simply do not have. At the same time, they're incentivized to apply for permits for temporary stay. Those are usually granted for reasons of economic activities, but they are, again, temporary, and they do not confer very substantial rights, and they're linked to this purpose they're granted for. And so, for example, when employment is lost, the permit is revoked. And so they are encouraged, Ukrainian refugees in Poland are encouraged to settle for this state of protracted temporariness and see their rights under temporary protection also eroded with time. They're made more and more narrower as political support for hosting them erodes. So to sum up this part of my talk, this concept of the gap between temporary refuge and asylum that I introduce denotes this legal space, if you will, where protection is granted but stability is withheld, and where emergency measures stick beyond the actual emergencies, becoming substitutes for durable solutions. In some contexts, and that is particularly where temporary refuge is of very minimum content, like in Lebanon, but also in Bangladesh, this gap, I argue, decimates chances for local integration, and the result is what is known as protracted refugee situations, and this in turn contributes to an ever-rising global numbers of internationally displaced people. That is not to say that states do not have tools at their disposal to mitigate this gap that exists at the level of international law. The first of those mitigation mechanisms, and perhaps the most obvious one, is the expansion of asylum eligibility. So the assumption here is that if the problem is that persons protected under temporary refuge are ineligible for asylum, the solution is to make them eligible for it. And so states that are not parties to the 1951 Refugee Convention, such as Lebanon, could accede. But in order to solve this problem of a narrow refugee definition under this treaty, states can also opt for broadening the definition of refugees so as to encompass all, so to say, de facto refugees. That is, those that cannot be returned because they fear substantial dangers, yet are not eligible for refugee status under the 1951 Refugee Convention. The alternative is to devise robust complementary protection regimes for them that would meet this definition of asylum. The second mitigation mechanism is a prima facie refugee recognition. So very quickly explaining what it is a mechanism of a very fast asylum procedure based on a presumption. It dispenses with those lengthy determination procedures. Instead, it confers refugee status in principle on everyone crossing from a certain territory in a specified period of time. And the result is that the element of time between admission to territory and the grant of a full refugee status, full asylum, is very short, is reduced to the minimum. And as such, it is a viable alternative to temporary refuge in mass influx contexts. I argue that pairing broad definition of refugee encompassing all those protected under temporary refuge with prima facie recognition, in fact, allows for the gap to be closed. And I will speak a few words about Uganda, who does this, together with all the caveats. And speaking about these caveats will later lead me to introduce the final mitigation mechanism. So Uganda applies both a very broad definition of refugee under the 1969 OAU Convention. It explicitly covers people fleeing generalized events, not only persecution, and it recognizes on a prima facie basis, in principle, every refugee coming from South Sudan, the Democratic Republic of the Congo, and Sudan. And so, de jure, the gap in Uganda is closed. However, this is not to suggest that the situation of refugees in Uganda is all great. It's not. And that is primarily because vastly insufficient funds at the disposal to tackle this refugee situation, to provide the refugees with means of subsistence. And in reality, this situation has been grossly underfunded for many years, especially now after the dismantlement of US aid by the second Trump administration. And the result is food insecurity and all sorts of risks and challenges that this drives. And this creates this situation of insufficient international support, insufficient funds at the disposal of Uganda. This creates very strong incentives to, quote unquote, reduce the numbers through toughening the policies that the Uganda employs. In other words, even though Uganda employs these measures that closed the gap between temporary refuge and asylum, it is actually incentivized to do the opposite, to introduce measures that would lead to encouragement of refugees to leave through cutting costs, toughening the policies, basically making life difficult for them. And this is illustrated by this quote that I chose to put on the slide. This is what I heard from a senior government official in Kampala that was interviewed for this book. And I would like to read it now from the slide because I think it illustrates very well the point that I am trying to make now. So this person said to me that the government introduced such a progressive policy, but it always expected the international community to meaningfully share the burden. At the moment, the burden sharing is insufficient. And so, through insufficient responsibility sharing and no focus on third country solutions, Uganda's policy shows its limits and its purposes are undermined because the resources at the disposal right now are not enough to secure refugee self-reliance. At some point, Uganda will have to say enough. There are safe zones in the DRC which Uganda and partners could explore through strengthened regional engagements at both the political and technical level, but it seems like no sufficient engagements are undertaken, so root causes are not tackled. In this sense, Uganda's open door policy is being exploited. And so what you can see in this quote is a substantial degree of frustration, right? With Uganda doing its part, opening the borders to refugees, providing them with meaningful rights, introducing this progressive policy, yet the international community did not do its part. And the result is that the situation of refugees in Uganda is actually very, very bad. And this leads me to the final mitigation mechanism, and I would argue that this is the most important one, and that is devising a meaningful global responsibility sharing. So right now, there is no duty of responsibility sharing in international law, and voluntary responsibility sharing is notoriously insufficient. And the result is that countries which host the bulk of the worldwide population of refugees, and those are primarily countries of the global south, are left to cope with large refugee situations largely on their own without meaningful support. And this creates, as I believe was illustrated by the quote I put on the slide before, this creates strong incentives to bear out the very minimum of their international obligations towards refugees. In other words, it encourages them to perpetuate the gap between temporary refuge and asylum rather than close it. And so I argue that in order to encourage meaningful mitigation of the gap, there must be proportional international assistance, either in the form of resettlement or substantial financial transfers. The extent to which this is wishful thinking, maybe I'll leave for the discussion, but I believe that there is no way around it in order to ensure meaningful mitigation of the gap, and for that matter, for ensuring that the global refugee regime operates efficiently. To wrap up now, so the book proposes to see the gap between temporary refuge and asylum as a lens through which one could analyze the operations of the global refugee regime, especially in those situations of large refugee influxes and how they're tackled over extended periods of time. It denotes this legal space where protection is granted but stability is withheld, and where emergency measures become substitutes for durable solutions. States do have viable means of remedying this situation, but unfortunately weak incentives to use them. And I argue that international law permits this situation, particularly because of the limits of the 1951 Refugee Convention and treaties that devise complementary protection that I spoke about before. And at times, unfortunately, international law also encourages such outcomes, and that is because there is no duty of responsibility sharing. And as a result, states hosting those substantial population of refugees are disincentivized from tackling the problem. I will wrap up here. If that was interesting for you, I encourage you to check out my book that should be out within a few months with Brill. For now, I thank you, and I'm looking forward to your questions.
Okay, thank you, Maciej, and perfect timing, about 24 minutes and 35 seconds. So let's open up for a round of questions from the audience in the room. Maybe we can collect a few and then you can answer, and then we can open it up for the audience online. Yes, Martin?
Yeah, thank you. It was very interesting. I want to base my question on your wishful thinking remark at the end. So, I mean, if you suggested, and I suppose most people who write on refugee protection recognize is that, I mean, there's two, kind of, it's a humanitarian issue, but also it's a inherently political issue. So in a way, there's conflicting considerations, protection principle, but also the kind of national interest. And in a way, as you have described, I mean, you could argue temporary protection has arisen precisely to deal with this conflict. So you framed it in terms of this quality versus quantity trade-off. So if that is the case, I suppose my question is, your solutions don't seem to engage the political side anymore. You say, I mean, legally, so you know, we just make everybody a refugee. Well, but I mean, we are in this situation because of these, you know, so what about public support? What about capacity constraints and all of that? So I'm not making a normative case, but I'm just saying, just as from an analytical perspective, to understand why this is happening, you seem to recognize there are these two things, but then when you make your recommendations, you kind of just go to only to one aspect of this. So yeah, so I suppose to me the obvious question is, well, yes, I mean, technically, legally, maybe these things will fix it, but you know, the national burden sharing has not happened. What might move the needle? What is it that would make a difference? And I do think temporary protection, the temporariness of it, has, as you rightly say, enabled a hosting of very large numbers that I imagine in other scenarios would have not been possible politically in many countries.
Any other? Yes, please.
Thank you very much. You have given us a very robust presentations of your work. I actually two questions for you, but I'd like to first to talk along with the previous speaker that you seems to tackle some legal aspect, but the political aspect has been withdrawn. Because this happened in one of my books I did in 2022 at the beginning of the Russia-Ukraine war, which I titled Echoes of Color Discrimination and Refugee Protection Regime, the experience of African fleeing Russia-Ukraine war. And in this place, though I couldn't come in person, it generated arguments. So,
sorry, could you speak up, please?
Oh, sorry. I said, I just want to brush on what he said regarding the fact that you have treated some of the legal aspects and you leave some political aspects out. Well, maybe it's not part of your work, which is okay, because sometimes when I also did a paper like that in Florence, it generated arguments when the war started, and I argued the fact that Ukrainian Africans were not given protection adequately, and somebody jump up like this. So the question I just want to ask you is that how long is a complementary protection, because you didn't define that in your work, how long is it, or onto which it could be expunged or could be accepted? I really want to know that contemporary complementary protections in your work. And secondly, what is your motivation for this study? What's your rationale?
Any other question? Okay, then maybe you can start by taking this too, and then.
Okay, starting with Martin and political aspects, but also the potential of temporary protection, temporary refuge to accommodate large numbers of asylum seekers. Maybe starting with the second aspect. Yes, I agree that it is in principle a useful tool. And the book starts from this premise that it's actually desirable. It's contributed to the situation where, you know, states are accepted or sorry, inclined to accept hosting large number of refugees. The problem emerges when it's abused beyond its purpose. And this is where this gap that I was talking about emerges. And actually, I frame this prima facie recognition as an alternative. So when you think about it, it does the same thing, right? It allows asylum systems to be safeguarded because we dispense with those lengthy individualized procedures. Instead, we confer on everybody, just as we confer upon them temporary refuge, we grant them immediately refugee status. And this is, I think, a viable alternative. And this precludes the emergence of the gap that I was talking about. On the politics of it all, of course, I am aware of all those pitfalls. And of course, I agree that, I don't know, if states were to revise the Refugee Convention right now, the outcome would be the relaxation of their obligations towards refugees rather than strengthening them. And so those proposals for a protocol on responsibility sharing that are put forward in the scholarships, maybe someday, definitely not now. But I think there are reasonable arguments that one could make in favor of that could be appealing if taken rationally, also to states of the so-called global north, to European countries, the US, etc., etc. And those are one that comes to mind, actually, is that states that are targeted by so-called instrumentalization of migrants. Right now, they are basically liable, or an argument could be made that they are to an extent liable to bear the costs of the instrumentalization because they contribute to the conditions that make this instrumentalization a viable strategy for hostile states in the first place. And so through providing meaningful responsibility sharing, not consisting in what is sometimes understood as responsibility shifting, right? That is barring the routes of secondary and regular migration, they could undercut the conditions that make instrumentalization or migration blackmail, call it as you will, a viable strategy in the first place. But of course, how to convince them that devising a meaningful responsibility sharing would benefit all is obviously $1 million question. And you know, political scientists, economists, all deal with it and all have dealt with it for a long time. This is not what the book is trying to do because I'm not an expert in this. But it actually ends with a call to interdisciplinary audience to continue working on strategies that would make the alleviation of the gap appealing to states that now hold all the cards in managing the global public good that is global refugee regime. Okay, and coming to the second question, I'm not sure if I understood it correctly, but the question was, how long is how long is too long or how long is adequate, right? So the purpose of temporary refuge is to deal with an emergency, right? So as long as you have those multiple border crossing, as long as there is emergency, there are problems with accommodating those people, I don't know, they are in reception centers, in camps or whatnot, I would argue that applying temporary refuge is justifiable. If there is no more emergency and those regular asylum system could resume, this is when the rationale for applying it ceases to be material. In the EU, the limit was put as at 3 years. And to an extent, obviously, the period that you set as adequate will be arbitrary always. But I guess you have to draw the line somewhere. Now, the motivation. This is a great question. So I've been dealing with this for so long that it's hard for me to say. I mean, this was my PhD project, so I came up with it, 6 years ago? And I guess I first wanted to deal with the relationship between non-refoulement and asylum. That is, this problem that in non-state parties to the convention, and also in state parties with regards to people who do not meet this persecution requirement that would allow to grant them refugee status, they also sort of fall in this legal gray space. But this has been tackled. And around the same time, temporary protection was triggered in the EU for the first time. And I was like, all right, this makes sense maybe to shift the focus to temporary refuge. And funnily enough, in the first article where I introduced this concept of the gap between temporary refuge and asylum, that was, I think, 2023, so a year after temporary protection was triggered, I was very optimistic about the potential of temporary protection of the EU temporary protection to mitigate this problem of the gap, because it involves tangible rights for protected people, and primarily because it provides for this transition mechanism, right? There is a period of 3 years after which it should be terminated and transition to something more lasting. So I was like, yeah, this is it, maybe, this is how the gap is dealt with. And unfortunately, what happened a few years afterwards is that, the conclusion of the book is that on paper, it looks good, but the mechanisms that the EU had embedded in its law to deal with the problem adequately were not utilized to that effect. And so the conclusion with regards to the EU and Poland are pessimistic, unfortunately. I was hoping I would have at least one positive case study, but I don't, unfortunately.
Thank you. So let's collect another round of questions from the floor, and then we can open up for questions from online. Yes.
Hi, Maciej. This is super interesting. And as someone who is in political science, I find this legal analysis super helpful, actually. My question is, do you have an estimate of how common temporary protection is and how common the prima facie approach is? I know that in the African context, that's rather common. But yeah, how common are they two globally? Thank you.
I don't have an estimate. What I can say that prima facie is indeed very popular in Africa and also in Latin America. And it is no coincidence that those are also the contexts where broad refugee definitions are applied. That's because those definitions make reference to general events, indiscriminate violence, right? Instead of individualized persecution, which makes it very convenient to apply this presumption that is the essence of prima facie recognition. So because we know, I don't know, there is a war in South Sudan, right? It is easy for us to presume that anyone crossing from South Sudan is in fact a refugee. And so there is no need to examine their individual claims. We just assume they're all refugees. We grant them prima facie refugee status. This is not the case in Europe, where the 1951 Refugee Convention continues to apply. This requires individual persecution. And so if persecution is understood as this individual kind of predicament, situation, it's necessarily, not necessarily, but this is how the convention is interpreted in Europe. Unfortunately, in my opinion, it requires this individualized, lengthy procedures based on interviews, etc., etc. So it is common in Africa and in Latin America, but yeah, temporary protection is applied, for example, in Colombia. And that is, again, I think, quite a good and positive example, because it also, similarly as in the EU, It entails significant rights, and also the resident permits that they get is 10 years, which is like substantial, right? It guarantees the sense of legal stability. But as regards absolute numbers, I unfortunately don't have them.
We should open, we have 2 questions from our community online, and I think there was somebody with a raised hand who might have also written the question in the chat. So to begin with, from Yana, what is your opinion about solidarity mechanism applied for states' responsibility sharing in case of temporary protection? I guess you could just answer each one.
Okay, so this is another, I would say, positive feature of the EU response. That's because the EU decided to allow Ukrainian refugees free movement across the Union. So the rule under the Temporary Protection Directive is that persons protected on the basis of temporary refuge should stay in the country of the first entry. That's Article 11 of Temporary Protection Directive. But under the directive, states also have the option to disapply this article, and they chose to do so. And the result was that the Ukrainian refugees, when they arrived, they spread out more or less evenly across the Union instead of just staying, in Poland or Romania. And so no relocation was necessary, for example. So this was actually a reversed logic done under ordinary procedures. And primarily, I mean the so-called Dublin system, right? That confines asylum applicants to the countries of first entry, and this leads to those, not so great results with hotspots in Greece and Italy, and this led to this calamity that we saw in 2015 on Lesbos, Kos, Sicily, etc. So this was, in my opinion, a good solution, and I argue that EU should draw also lessons maybe for reforming those ordinary procedures under the common European asylum systems in the future.
Thank you. We also have, before we proceed with the other 2 questions in the chat, somebody will raise their hand. Irina, would you want to ask your question? I'll just turn off the mic and you should be able to ask the question directly.
Thank you for letting me talk. I started to type it in the chat, but it is rather a comment than a question. I'm social psychologist, and I keep challenging lawyers which see this temporary protection regime in quite a different way than psychologists. First of all, I wouldn't generalize temporary protection in EU in general, because temporary protection in France is very different from temporary protection in Germany. And in France, what is very important for highly qualified migrants, Ukrainians under temporary protection of France are allowed to work in other countries. So in general, and keep temporary protection in France. So in general, this temporary protection regime is very beneficial not only for Ukrainians, especially highly qualified Ukrainians, but also for local host societies. Ukrainians are able to choose country in which they are able to contribute to local society with their resources and their skills, as well as local society can benefit from our contribution. And in France, there is possibility to apply for subsidiary protection, but very small portion of Ukrainians used this ability because we prefer to keep our rights having temporary protection of France, even with very low social security benefit, financial, but we have rights to work and we have rights to live in different parts of France, and we have rights to work in other countries, which is very important for us. Thank you.
Yeah, I don't think there is anything to add. I think you illustrated very well what I was trying to say. So in France, as I assume, there are strong incentives to just keep with the status of temporary protection, even though it makes people reliant on those successive extensions, and nobody knows what will happen under 2027. So this is exactly the point that I was trying to make when I was speaking about Poland. And of course, I fully agree that, of course, it's truistic that temporary protection in each and every country of the EU is different. There are some minimum standards that are outlined in the directive, but then states implement their own policies. So in Poland, what we're seeing right now is that what happened in the beginning, the first year of temporary protection, the status of temporary protection was incredibly favorable. It was much more favorable than refugee status even. It was basically national treatment, even with preferences for refugees over citizens in certain areas. To give you an example, Ukrainian refugees could be employed at the academia without an open call, simply because they held professorship in the Ukraine. They could just come and be employed without an open call. And this has been significantly eroded over time, to the point that I would argue in some areas, Polish temporary protection is not in compliance with the directive anymore, in some aspects. Yeah, this is it. Thank you.
Okay, we have two more questions from online in the chat. So one is Captain. Do you think prima facie recognition of refugee status is the way to go for the EU to transition out of temporary protection for displaced people from Ukraine, for those who can't apply for other EU legal statuses?
I would love that. So yes, and it has been argued already, for example, by Melta Minelli-Sigre, that this is the way, because the current approach under the strategy that Commission published on transition from temporary protection, the Commission actually discourages states from offering asylum, refugee status, or subsidiary protection, and instead advocates for granting those national legal statuses, like the one I talked about, permits for a temporary stay in Poland. And this one perpetuates this temporariness, and second, it leaves behind, or it risks leaving high and dry, those who cannot meet the conditions for those national legal statuses. So for example, for those permits for temporary stay in Poland, as I said, they are granted for specific reasons. For example, to enroll in a university or for employment. If one doesn't meet the conditions, one cannot obtain it. If one loses the employment, one loses it. And so it risks leaving behind basically the most vulnerable people. So yes, I believe that prima facie is a way to go. Do I think that this will happen? Absolutely no.
And okay, last question from Ewa from OECD. Thank you for your very interesting work. If ever in a post-2027 context, member states have to transition from the temporary protection framework, what could be the most effective way to transition to a more stable access to protection in practical terms?
I think this has been said just now. I would argue, and this is the argument that the book adopts, prima facie refugee recognition. This is a solution that takes into account specific conditions of displaced people. It doesn't leave behind anyone who justifiably fears returning. This is the way to go. Yeah, I don't think there is anything to add. Thank you.
Thank you. Okay, is there any other question online or? Okay, Marty. Oh.
Sorry, can I just push you on the final point? If you had a second best policy, since you said you don't think it's going to happen, what would it be?
That's a great question. I think either this, probably maybe prolonging temporary protection, but for how long can it be extended? I don't know, like at some point there will have to be transition to something, right? So the current approach is that temporary refuge is successfully extended each year, basically, and some avenues are created for protected people to apply for those national legal statuses. This is suboptimal, but that's better than, I don't know, repatriation, involuntary repatriation to danger, or I don't know, creating conditions that would push these people to return, quote unquote, voluntarily, right? And I said quote unquote because, you know, the extent to which this would be voluntary, if, I don't know, the rights were eroded to such an extent that this would not be a viable option for them to stay, to what extent you could call this voluntary. So I guess this is the second best option. That said, it's far from ideal.
Thank you. Do you have any other question? Okay, then please join me. Oh, yes, Olya. I'll turn my mic on.
Thank you very much for your talk, and that and you raising very important points. And I specifically wanted to ask you about the aspect of permanent residency, because with the 27, we're also approaching the deadline when Ukrainian displaced people under temporary protection have this conundrum of basically theoretically could be eligible, but the directive is silent. So it also is another aspect when it grants to the state basically powers of deciding whether to recognize these years, and especially for the people who are transitioning to also to other employment-based statuses. So how do we count this, the time of legal stay? And so if you could comment on this and how you see the resolution of this paradox, and also do you see any way of who and how, whether there can be actually a challenge, a legal challenge to the EU treatment of the of people under temporary protection with respect to the obligation to provide protection, and whether it is sustained.
So starting with permanent residence, hopefully such a possibility will be provided by states. I would expect this to be mentioned explicitly and specifically in this recommendation that was issued by the Commission. It wasn't. Maybe when the decision will be to finally terminate temporary protection, such a recommendation will be made to states. Again, hopefully, but I have no idea whether this will be the case. On the legal challenge, I mean, on what level? There are so many ways one could challenge that. One could challenge it before in the national courts, before the European Court of Human Rights, before the Court of Justice of the European Union. Since we're talking
let me reformulate. Maybe do you see any attempts to to formulate legal challenge at some level? Because there seem to be such a widespread, that you also mentioned, of basically celebrating temporary protection as a very beneficial regime. And like we in our work, I mean, me and my co-authors, we are also touching on these points, but that there seems to be almost a consensus at all levels. So I was wondering, as a legal scholar, do you see any actors who try to develop now this challenge?
Of course. So I can talk about the Polish context, which I am the most familiar with. So there are plenty of challenges related to specific aspects of the operations of the Polish temporary protection. For example, people challenge losing the status of temporary protection because they left, but they lost it before this deadline of 30 days for some reasons. And this has been challenged in front of administrative courts, for example. Now, the extent to which, or I don't know, the probability of those cases reaching Court of Justice of the European Union depends obviously on the willingness of the courts to refer preliminary questions to the court, because access for individuals to the Court of Justice of the European Union is very, very limited. Another possibility, but this I would not count on, this is the infringement proceedings by the Commission, taking member states to court. And I would argue that some states, and Poland in particular, could already easily be taken to the Court of Justice of the European Union for certain aspects of its policy towards the Ukrainians. However, the Commission is notoriously, in my opinion, unwilling to hold states to account in migration aspects. So I wouldn't count on that. And unfortunately, access to the Court of Justice is otherwise very limited. It would depend on national courts to what extent they are willing to ask preliminary questions to the Court of Justice.
Okay, we have reached the end of the seminar. Thank you again, Maciej, for this very interesting presentation, and thank you everybody in the audience and online for participating, and have a great afternoon. Thanks.